Hello friends, Namaskaram. In nowadays, the anti-corruption client is facing a common problem on the part of ACB or CBI because they used to mention on the case file that the accused is not having the good reputation. He used to ask for the bribe and without bribe, he never executed the work. So basically, we have to understand the problem, then fundamental, then strategy, what to do in that scenario. And we have to understand whether these evidences are relevant or not. So directly I'm moving on the board, I will specify you certain points. Please try to note down the same. First of all, we have to note down the problem. Whether bad reputation of accused could be relevant in anti-corruption case or not. The answer is no. Simply we have to rely on section 49 of BSA, which says in a criminal case, the fact that accused is having the bad reputation or character, it is irrelevant. Means the evidence is inadmissible. Now we have to apply that formula in anti-corruption case in limine. Anti-corruption case is basically a criminal case. Am I right? And there might be fact on record that you are having the bad character or reputation, but there is no consistency, there is no corroboration. Without that, a fact cannot be proved. And apart from that, the fact of bad character or reputation is itself irrelevant. And when a fact is irrelevant, it is inadmissible and it could not be proved against the accused. Please be noted, it is called the golden rule. But there are two exceptions. Number one, the section will not apply if the bad character of accused is fact in issue, the previous conviction is also relevant to calculate the bad character. So in a corruption case, you are not previously convicted and the fact in issue is whether corruption is done by you or not. Your bad character is not fact in issue. So in that scenario, it could not be considered as relevant fact. So now we are clear about the problem and fundamentals. Now we are coming on the strategy. What to do? If there is any remark, just file an application before the court as per section 49 of BSA to remove the incriminating facts being illegal. We have to submit that in a case of Prevention of Corruption Act, the fact of bad reputation is irrelevant and that's why it is required to be removed. And apart from that, we have to specify that the fundamental of previous conviction, and apart from that, the bad character is not fact in issue and that's why it could not be considered. And whenever you file the objection, the court will issue notice to the concerned state regarding the explanation, and if they fail to explain the four important points: previous conviction, fact in issue, evidence or source regarding that fact, number 4, corroboration. In that scenario, it is required to be removed from record. So basically, we must keep in our mind that the authorities are bound to follow the rule. If they collect the evidence or sustain the evidence against rule, it is our right to challenge the same by the way of objections. So simply we have to file the objection so that we could stand up a good case on board. Every proceeding must be as per the norms and as per the rules and regulation. So I think that in the easier manner I have specified you what you can do if in the illegal way it is mentioned that you are not having the good reputation. See you in the next video.